Good day to you and welcome to another Paddocks Club tutorial. Today we're going to look at the question, what can schemes expect from their managing agents? And we're going to do this on the back of a question that Stephanie of Benoni asked recently. She gave some background in the discussion forum, and this was that the body corporate is litigating with the developer, that the managing agent has an ongoing relationship with that same developer and manages a number of his schemes, that the managing agent is being taken instructions from that developer, and the managing agent forwards intimidating emails from the developer's lawyer to owners. And Stephanie asks, who does the managing agent take instructions from? All owners or the trustees? The answer clearly is the trustees. They are the people who, in terms of the Act, carry out the functions and powers of the body corporate, and it's they to whom the managing agent reports. Is the managing agent obliged or allowed to send out emails to owners without the approval of the trustees? Certainly not emails of this sort. Is the managing agent allowed to alter minutes of meetings of an AGM on other people's instructions without the approval of the trustees? Absolutely not. Let's look at this slightly more widely. So we're taking the topic of what can schemes expect from their managing agents and looking at it in the abstract. Let's start off with the duties of trust and honesty. Managing agents must act fairly and professionally to all parties in the managing agency relationship. They must account to schemes regularly, I think at least every 3 months, but probably much better every single month, for all income and expenditure. They must act in the best interests of the scheme at all times, unless it would in fact be unlawful for them to do so. They must act in accordance with their instructions and the contract that they signed. They must ensure that their employees are reasonably trained. They mustn't mislead scheme representatives. They mustn't misuse scheme information. And they must not falsely pretend to represent a scheme. Finally, they must avoid conflicts of interest, and that seems to be Stephanie's main problem in this particular case. Let's move on to the duties of skill and care. A managing agent must exercise reasonable skill, care and diligence, reasonable in the circumstances. They must have a working knowledge of law and practice relating to scheme management. They must ensure that scheme levies are calculated and collected in accordance with scheme governance documentation, the Act and the rules. They must not mislead any person as to the effect of a provision of the Act or the scheme governance documents. Moving on to the duties in regard to money, and this is where most of the trouble, the big trouble really happens. They must deposit scheme money to an interest-bearing account. They mustn't mix monies held for different clients. They mustn't mix their own and client money. They mustn't pay client money out without permission or take it. They must account to a scheme regularly and fully. And if we look then finally at the professional duties of a managing agent, they mustn't mislead people about their services in advertisements. They mustn't bribe or give kickbacks in money or otherwise. They must abide by all applicable codes of conduct. They mustn't falsely pretend to be independent of any service provider. They must cooperate with incoming managing agents when their mandate is terminated and they're outgoing. They must hand over the money and the books and all that sort of thing. And they must have a comprehensive contract that covers all relevant issues. Thank you very much for joining me in this Paddocks Club tutorial. If you have any questions, let's deal with them in the discussion forum.